So my name is Amrita Chaudhary, and on behalf of CCAOI, CUTS International and Internet Society Delhi, we welcome you to this discussion on Data Protection Bill 2021, and we are trying to decipher the privacy and rights of minors. As I mentioned earlier, this meeting is being recorded, live streamed, and we will be sharing the link with the community later. Now, the reason for discussing about minors, and for us, minors are anyone who are aged below 18 years. They account for nearly 39% of India's population and constitute the most active internet user base of the country. And there is a growing concern about their security and privacy online. They are vulnerable and they need to be protected. However, there is also a need to ensure that while protecting them, their right of privacy and speech and even expression is protected. As you are aware, after 2 years of deliberation, the report of the Joint Parliamentary Committee, which is also known as JPC, on the Personal Data Protection Bill 2019 was released in December 16, 2021. And the report is now titled Data Protection Bill 2021. This report captures the JPC's recommendations on the changes that should be made to the Personal Data Protection Bill 2019, along with some recommendations related to privacy and data protection. We'll share the bill and the report in the chat. And today our objective is to discuss, and have a better understanding of the provisions related to processing of data related to minors. Also deliberate on the areas which probably needs to be refined, and then deliberate what could be, the constructive regulations or codes of practice for minors' privacy. After this discussion today, what we want to do is we want to, based upon the inputs, we want to create a community document where all organizations or individuals who are interested to contribute can put in their thoughts, and they will all be attributed. And this is to create a constructive regulation of codes of practices and how it should look like for, when we are dealing with data of minors. And everyone is welcome to it. So before we begin, we have a few housekeeping rules. We follow the Internet Society Code of Conduct, and Siptin, may I request you to post it in the chat. Anyone can, you are free to chat, put in your comments. If it's a comment, please prefix it with a comment. If there is a question for any speaker, please prefix it with a question. The speakers will try to address it in their interventions or in the chat, and would request you to mute your mic if you're not speaking. And if you want to speak up during the open discussion, you could raise your hand. So this is about the housekeeping, and as you have seen, we have a distinguished panel of speakers today who would be sharing their perspectives, their individual perspectives or individual perspectives of the stakeholder group they come from on this issue. And we are really happy to welcome the two honorable MPs who were also members of the JPC on the PDP Bill 2019, Mr. Manish Tiwari and Dr. Amar Patnaik. Both of them have been actively involved in the data protection discussions and also several tech policy discussions. And we welcome both of you, sirs, for taking out time from a busy schedule to be here. Along with them, we have Aparajita Bharti, who is from Young Leaders for Active Citizenship, Srinidhi Srinivasan from Ikigai Law, Uttara Ganesh from Snapchat, Nikhil Pava from Medianama, S. Chandrasekhar from KNS Partners, Amol Kulkarni and Siddharth Narayan from CUTS. And we'll have the agenda of today posted in the chat, Siptin, if you could do so. So without much ado, we'll just we invite Srinidhi first to come and share a brief overview of what the provisions related to minors are in the proposed Data Protection Bill 2021, and also highlight if there are any deviations to the PDP Bill 2019, and if there are any differences with other data privacy laws of any other country. So, Srinidhi, do you have the rights to present? You have a presentation. Can you just speak up so we will be...
Hi, Amrita, can you hear me? I actually am unable to present. It's
just a second. We will give you the rights.
Sure. Very good afternoon, everyone. Thanks so much for having me here. And hello, everyone, Dr. Patnaik, Mr. Tiwari, and everyone in the room. I think to set, like Amrita said, to set the context for today's discussion, I'll just set out a quick overview of the JPC recommended bill and what they say about children's data, in particular, draw out some of the key differences from the 2019 version and offer some thoughts based on a quick comparison with US and European laws, just as a frame of reference.
You can share your screen. Just try it.
Yeah, it's working now. Just allow me 10 seconds.
Do you want to go on a slides share mode?
Yeah. Can you see the slides now?
Yes, this is great.
Okay, great. Yeah, thanks so much. So I think like everyone in the room knows already, I think the data protection bill sets out certain do's and don'ts for organizations collecting any type of personal data. It calls for an overall privacy by design approach. There are rules around collecting data, what privacy policies should contain, how do you get consent, transparency measures, etc. All of these, of course, continue to apply when you're collecting and using children's data as well. And I'm not going to go into those general provisions around collecting and processing any type of data. But in addition to those, the law acknowledges that children are a vulnerable section of the society, and there are some special protections needed when it comes to organizations that are handling, collecting and using children's data. And the law sets out certain additional do's and don'ts for such organizations that are dealing with children directly or that are collecting their data. So I think, and that's what I'll touch upon today in this overview. So I think the first couple of requirements are that before you process any data of a child, an organization must verify their age and also get consent from their parents or guardians. I think a couple of things to unpack here. First, just being how child is defined in the law. Child is defined as anyone below the age of 18. And the JPC does discuss this age requirement, looking at what other countries have done as well. But it chooses to go with the age of majority in Indian law, where you can validly enter into a contract, which is 18 years of age. And so the first step for any website or app or online service would be then to
recording in progress.
To verify an individual's age before collecting any of their personal data. If they're under 18, then you can't collect individuals' data unless the individual's parent has consented to such collection. So interestingly, this extends to all organizations, whether they are directed at children or not. So even if it's a news website, which say allows website visitors to register for weekly or daily newsletters, for which you have to enter your name and email ID, there must be, this calls for some kind of a checkbox or some kind of a confirmation that that person is over 18. Like our own website has a contact us column. So would that mean that before collecting, we must also have some kind of age gating or age verification method? The precise method of age gating is left up to regulations, and the law says that the manner of age gating should be based on the possibility of harm to an individual, the likelihood of collecting a child's data, or the volume of children's data that is processed. And we just looked at, I mean, this is an area we've been researching on, and just looked at a couple of sort of examples of what these kind of age verification methods might look like. It could just be something as simple as self-confirmation or check boxes, where you check a box saying I am 18, or in the midst of a form, you also enter your date of birth. And if it does turn out that you are below 18, then the next step there would be that that platform has to get your parent or guardian's consent. And I think the law doesn't set out a lot of granular details on it, and because the idea might also be that say a news website may have a different lower level of sort of harm associated to an individual versus say something like a dating app where the potential of harm to a child's privacy may be more extreme. So whether what kind of confirmation or age gating mechanism will work is left up to sort of codes of practice and regulations. And like I said, I think if it does turn out at this stage that the person you're dealing with is someone below the age of 18, then you must get their consent. The manner of this consent is also not set out in the law, and it's perhaps impossible also to exhaustively set out how this will work out. But again, a couple of examples that we've come across from other jurisdictions and from existing practice as well. It could be something like asking the child or the individual to enter a phone number, their parents' phone number or email ID for OTP verification. Or it could be a knowledge-based authentication, some kind of quizzes or questions that only an adult will be able to solve, or sort of call center-based verification where you send a toll-free number for parents to call and confirm, official IDs or AI-based verification. Now, I do understand that many of these might not be foolproof. Kids have their own phones. Kids may be able to answer some GK questions better than I might be. Call-based verification may add a lot of friction to the entire process. Official IDs or AI-based verification will mean even more data being processed. So I think what the point I'm also trying to bring out is that it's expected that the law or the codes of practice might hopefully will account for this kind of.
एक तो बर्तन की क्लास चल रही है, बर्तन खाली करा दो, मम्मी के पैर में थोड़ी सी मोच आ गई।
May I request others to be muted?
बर्तन खाली करवा दो और सब चीजें अंदर अंदर रखा दो, फिर सारे छोटे
Hi, yeah, could I request everyone to go on mute, please? Thank you so much. Yeah, so just picking on, I think the overarching idea here being that sort of prescribing anything very granular here might be challenging and will not serve the purpose as well. And it's hoped that codes of practice or regulations that come out account for some of this friction, and perhaps there's a risk-based sort of spectrum of options that are presented as examples. Like a 17-year-old subscribing to a newsletter might be very different from a 9-year-old trying to enter a dating app. So just that's sort of one level when of before processing or before collecting a child's data, what are the things to do. The second set is when you're already an organization that is collecting and processing data of a child. The law says that an organization cannot profile or track or behaviorally monitor or show targeted advertising or do any other activity that can cause significant harm to an individual. Now, I found this to be an interesting restriction where, and I believe others in the room could speak to this more authoritatively, but say in our past conversations as well, child rights organizations, for instance, say that this could restrict some of the more beneficial profiling that they do. For instance, predictive profiling to understand kinds of interventions for a vulnerable child. Or within a school or an edtech platform setting, you often get tests and quizzes based on your previous performance, which also has an element of profiling there. The law does have one exception carved out, which is for child counseling services. But perhaps there may be many more instances of beneficial profiling. And one way to look at this restriction could be that it's intended to restrict profiling that can cause significant harm to an individual and not beneficial profiling. Certain other requirements process a child's data in a way that protects her rights. And the framing here is child's rights, as opposed to the 2019 bill, which had recommended that you process data in accordance with the best interests of a child. So there's a point of departure there. And the third requirement is that if you provide a service to a child or you process children's data, then the government may designate that organization as a significant data fiduciary. And if so, then there are certain heightened obligations that are applicable to that set of entities. You must register with the authority. You must conduct data protection impact assessments before carrying out any high-risk profiling or high-risk processing activity. There is a requirement for periodic audits and so on. So that's sort of that's what the requirements in the Data Protection Bill 2021. And I think a couple of the differences from the earlier version I did mention. One is the concept of best interest is now sort of changed to refer to rights of a child. The second being that the earlier version had a concept of guardian data fiduciaries, a different category of data fiduciaries that were aimed at children or that process large volumes of children's data. Only those were barred from profiling, tracking, etc. And now all DFs, all data fiduciaries face that restriction. And the third set, the committee also recommends that the government should come up with rules, for instance, for allowing individuals who turn 18 the ability to withdraw their consent within, so before 3 months of them turning 18, they get the option of revoking that consent that their parents may have given them. But these are not text changes. The JPC leaves this to the government to come up and devise rules on. And I think just a couple of themes to summarize and maybe offer some contrasting perspectives. One theme seems to that's come up frequently in conversations is just the age of a child. A lot of stakeholders say that 18 may be just too high for parental consent, and allowing parents to monitor and sort of call the shots. And especially in settings where a child may come from an abusive household or even otherwise, where they're looking, say, for information on sexual orientation or other themes that are taboo in their homes, having a safe space for them. And just as a point of contrast, so some other jurisdictions like US has a Children's Online Privacy Protection Act, and there the requirement for consent is pegged at 13. In Europe, it's 13 to 16. Then in terms of which are the kinds of platforms that need parental consent, I think the Indian law extends this requirement to all organizations that interact with any individual, sort of having some kind of age gating mechanism. In other jurisdictions, this seems to be a little narrower, where it's sort of websites or online services that are directed at children, because the likelihood of harm or the likelihood of them coming in contact with kids is a lot more. And just on this restriction on profiling and monitoring as well, I found this interesting that some other jurisdictions either allow it with parental consent, though there may be restrictions in other laws in specific settings. And say in Europe, as such, there isn't an absolute prohibition, but you must conduct impact assessments and still must abide by all of those privacy by design principles and make sure that you are kind of taking into account a child's privacy at every stage in the process. So that was just an overview and a summary of some of the big themes in the new law. I will pause there and I'll just stop.
Right. Thanks, Srinidhi. So may I quickly bring in Siddharth? Siddharth, quickly, could you share what KUTS has been working on? Because I believe Mr. Tiwari and Mr. Patnaik would have to leave early.
Sure, thanks Amrita and Srinidhi for setting the context. Just give me a second, let me just share my screen with everyone. I hope it's visible. Okay, so before delving into the findings, I will just take a minute to discuss the sample spread of the survey. More than 1,200 respondents were surveyed from different parts of the country. These included parents as well as young users, that is those aged 16 and 17 years. A mixed sample spread was taken with respect to respondents' gender, geographic location, and parents' age and education levels. We surveyed only those respondents who were users of digital technology-driven services. Through the survey, we have tried to gauge the perspective of parents and young adults on the issue of protecting children's personal data under the Personal Data Protection Bill. So moving on to the findings now. As mentioned by Srinidhi, Clause 3.8 classifies users under the age of 18 years as children. The survey found that most young users avail various popular data-driven online services, and many do so without the knowledge of their parents. Notably, a significant number of parents are comfortable with their children availing such services without their permission, and also claim that children start using internet-enabled devices without any parental guidance from an early age of 14 years. Accordingly, there is a need to revisit the age threshold of 18 and have inclusive stakeholder consultation for fixing a lower age threshold, as has been done in other countries as well, like US and EU. Having stakeholder consultation would be useful in this regard. Moving on, clause 16.2 mandates data fiduciaries to obtain parental consent before processing children's data. However, our survey found that most parents believe that their children know more than them about practices to adopt for a safe online experience. They also consider children to be capable enough to provide consent to the terms and conditions of service providers, a claim which has also been seconded by young adults. Separately, most young users do not want parents to monitor their online activity, and they claim to value privacy equally from all stakeholders, that is, whether it is service providers or the government, their friends, or even their parents. Therefore, the requirement of service providers obtaining mandatory parental consent for all services may be relooked at, especially with respect to young adults, that is, those aged 16 and 17 years of age. The survey also found that many young users encounter different types of problematic experiences online, which could include cyberbullying, cyberstalking, exposure to different kinds of problematic content, etc. While most young users claim to be aware of various tools and strategies to overcome such problematic experiences, we found that many do not actually implement or adopt them. Accordingly, it becomes necessary for the government and service providers to work with consumer groups and child rights groups to raise awareness and build capacity of children on online safety. However, it remains to be checked if the Data Protection Bill is the right legislation to address this issue. Lastly, Clause 16.5 bars service providers from profiling, tracking, or behavioral monitoring of children. However, most parents and young users are comfortable with service providers taking different measures to ensure a safe online experience, including tracking and monitoring children's online activity. However, this has to be restricted only for ensuring a safe online experience for children and for not any other purposes. Accordingly, there is perhaps a need to permit service providers tracking online behavior of children with certain safeguards, upholding purpose limitation, data minimization, data limitation, etc. The survey also found that parents and young users prefer the use of technology for age estimation of users rather than linking an ID card. The DPA may frame appropriate codes of practice for age verification mechanisms under Clause 16.3 and 56H. Cuts has also prepared a briefing paper on the subject. We would be posting a link of the same in the chat box for everyone's reference. This slide deck would be uploaded on our website, and we would also email it to all participants. Any thoughts or suggestions are welcome now, or maybe during the panel discussion, or later separately as well. So thank you so much for your patience and kind attention. Back to Amrita.
Thank you, That. May I now request, I have a question for both the honorable MPs. And again, once again, thank you for taking out time and being with us. The question is, as members of the JPC, we would request you to kindly provide your thoughts on the recommendations made by the JPC in its report with respect to protecting children's rights. We would also be grateful if you could shed some light on the various dissent notes on the subject and what your take would be on the way ahead. May I request Mr. Tiwari to speak first and then Dr. Patnaik? Hope that's okay with both of you, sir.
Good afternoon, ladies and gentlemen. Am I audible?
You are, sir.
Thank you very much for inviting me to this discussion today in the afternoon. May I also thank my honorable colleague, Dr. Amar Patnaik, who's also with us, that he was able to spare time out of his busy schedule. I heard the presentation which was given carefully, as also the results of the survey which were shared with us on this platform. May I commence with giving you a brief overview. Of course, this is a very distinguished and enlightened audience, so some of it may be regurgitation. But nonetheless, let me provide you with an overview as to how we really came to the Personal Data Protection Bill. The Supreme Court, when it was hearing the Aadhaar case,
India has a draconian surveillance regime.
The Supreme Court, when it was hearing the Aadhaar case, had to deal with the formulation as to how do you really quantify privacy. And so therefore, a reference got made to a larger bench, and a 9-0 bench of and a 9-judge bench of the Supreme Court unanimously held that the right to privacy is a fundamental right flowing from Article 21 of the Constitution of India. Subsequently, as the Aadhaar matter progressed, the Supreme Court in its judgment opined that the government should actually come out with legislation in order to protect the personal data of citizens/people. As a consequence of that, the government appointed a committee under Krishna. I think you'll have to tell people to go on mute, otherwise. So the government appointed a committee under Justice Sri Krishna, and the committee made recommendations and also appended a model bill along with their recommendations. Subsequently, the government introduced its own version, or the government version of the Personal Data Protection Bill, which differed substantively from what Justice Sri Krishna had recommended. And the bill was finally referred by Parliament to a joint committee of both houses called the JCP, the Joint Committee of Parliament on the Personal Data Protection Bill. This is, I guess, nomenclaturally different from a joint parliamentary committee, but that's a finer nuance I will not go into at this point in time. When the bill came before the committee, unfortunately, we were hit by the first installment of the pandemic COVID-19. And after a very brief 2 or 3 sessions, the committee adjourned because there was a national lockdown. And then subsequently, in the midst of the raging first wave, when there was no vaccine around, some of us brave souls, Dr. Amar Patnaik and some other colleagues included, sat through from the July of December 2020 in order to go over the bill clause-wise. We wrapped up our discussions before 2021 dawn. And then the committee went into an interim for about 7 months, whereby there was no sign of any report of the committee being circulated to the members. This was followed by a cabinet reshuffle, and the then chairperson moved on to the Council of Ministers to be replaced by a new chairperson, who then looked at what had been done by the committee, and in his wisdom decided to suggest a series of amendments to what we thought was a frozen draft as we left it in December 2020. The good thing which happened was that it gave all of us time to really reflect upon the work that we had done. And in my estimation, I concluded that the Personal Data Protection Bill was entirely flawed. And so therefore, in my dissent note, I have in fact rejected the bill in its entirety. And the reason why I have rejected the bill in its entirety, because I find that the bill actually cleaves the entire universe into 2 parts. Insofar as the private universe is concerned, or the private space is concerned, the bill will be enforced with all its rigor. But insofar as the government space is concerned, the government space is riddled with exemption clauses, breakouts, blanket exemptions in terms of Section 12, in terms of Section 35 of the bill. And in my estimation, or in my humble experience as a lawyer going back now 3 decades, it's my view that a fundamental right is essentially enforceable against the state, and it is not enforceable against private entities to that extent. So therefore, if the right to privacy was the sine qua non of the entire data protection bill, then obviously there could be no scope, or there could be no wiggle room for having clauses which have the ability to exempt the government lock, stock, and barrel from the provisions of the bill. And this fundamental flaw in the design of the bill, which, as I pointed out in my dissent note, seems to have been the legislation seems to have been conceived by people in a pre-Puttuswamy mindset. Unfortunately, completely and absolutely brings into question the constitutionality of the entire legislation per se. In addition to that, Dr. Amar Patnaik would dwell upon it at some length, because that's a fundamental objection which he had, and I concur entirely, was that the bill impinges upon federal-state relations. In other words, you will have a central legislation which is going to be manned by appointees of the central government, really having superintendence and authority over data which falls completely and absolutely within the purview of the state governments in terms of List 2 of Article 246, 7th Schedule of the Constitution of India. So therefore, there are serious problems with this legislation. Now, the question would be that if there are problems, then why did we not address them? And that has something to do with the tyranny of numbers. The government had a very clear majority in the Joint Committee of Parliament, and everything ultimately would have been voted upon, and it would have been passed by a substantive majority. And therefore, we thought in our wisdom that rather than adopting that course, we should dissent from the substance of the bill, which would then provide enough room and ballast to argue its constitutionality later on in a court of law. Insofar as the specific subject which forms the grist of discussion today with regard to the age of consent of a child, I can share it with you that the committee deliberated upon it for a fairly extensive amount of time. We had heard expert witnesses, we had taken evidence, and some of us were of the view that this blanket determination of the age of a child really does not do justice to the digital universe that we live in. And especially as it has been pointed out, that compared to some people like me who are in the process of losing their hair, and some people like Dr. Amar Patnaik, who unfortunately has lost his, there are a large number of younger users who are far more savvy, as to how to navigate the digital space. And that's why in my dissent, I had specifically said that insofar as definition clause 3, subclause 8 is concerned, or section 3, subsection 8 is concerned, that the definition of a child should be different for accessing different categories of content or data. For example, for children's learning websites, online schools, school curriculum, children's entertainment, games websites, cartoons and news websites, etc. that are certified as child-friendly, no age stipulation should be necessary. For other content, similarly, the age stipulation should be defined by the DPA through regulations or directions. And the reason why I chose to move this specific dissent to what is the recommendation of the committee is because I find it to be a complete oddity that for a young adult of, let's say, 12 or 13 or 14 years of age, to actually get parental consent every time he tries to navigate the internet or get onto a website is a bit of an oxymoron. And it is actually going to create a universe of deceit. It's the classical example that comes to my head is about states in this country which have prohibition, which are ostensibly supposed to be dry, but you actually get the cheapest alcohol in those states at maybe every dry cleaner store. So therefore, you are actually incentivizing the creation of an universe of deceit and duality by subjecting young children to this kind of a provision. I can understand the concern, and all of us are very sympathetic and sensitive to the concern that there is a lot of stuff on the internet in the digital space which should not really be accessible for children. And then, of course, we are talking about the flora and fauna of the internet. We are not even dealing with the dark net and its various other manifestations. But a far more sensible and a rational way needs to be found. And I think if there are some suggestions which will be thrown up during the course of these discussions, when the bill comes up before Parliament for consideration and discussion and consideration, and finally passing, maybe we could flag it at that point in time. But I really do not see the government, given the manner in which the current government is, which it is not very friendly to any wisdom from outside, really attempting to change the letter of the law. Insofar as the Data Protection Authority is concerned, in fact, the Data Protection Authority is going to be an extremely overloaded entity, which is going to become completely and absolutely overwhelmed by the sheer volume of the work that it will be asked to perform. Because I can share it with you that in 2004, when the broadcasting sector was given to the Telecom Regulatory Authority of India by one of my predecessor ministers, the late Mr. Pramod Mahajan, we were talking of only about 800 television channels. And since from 2004 till 2022, TRAI has not been able to develop the competence of even regulating the techno-economic character of the broadcasting space. And here you are going to be dealing with millions and millions of data fiduciaries. And so therefore, there are large parts of this bill which in my humble estimation are completely and absolutely unimplementable. And then, of course, there is the cost of compliance. Right? The cost of compliance for smaller entities is going to be so humongous that it is going to completely kill the startup ecosystem in this country. And so therefore, as I said, that these concerns were repeatedly flagged. We argued, we even quarreled like little children in the JCP, but unfortunately, the tyranny of numbers had its way. And I'll stop at that, and I'll hand over the floor to Dr. Amar Patnaik, whose wisdom I have always been a great fan of. Thank you.
Thank you so much, sir. Dr. Patnaik, we would like to hear from you.
Thank you, Manish ji, for such very kind and generous words from a senior colleague, senior leader in the Congress party, and senior leader in politics per se. But as he elaborated on the two basic problems in the design of the bill, the number one fact that most of the areas of concern are the basic two issues basically which he talked about. One which he has mentioned in his dissent note, which I have mentioned in my dissent note, which I raised, I think, probably in the 6th of the 7th day of the 7th session of the sitting of the committee, is relating to the fact that what we have seen, that most of the cases relating to fundamental rights which are agitated before the constitutional courts under Article 32 to 26 are basically against the state. So the interpretation of the court of the Supreme Court in the Puttaswamy case by putting informational privacy as a part of the right to life under Article 21 basically guarantees the citizens this right by the Constitution itself. And most probably it will be the citizens who will be running to the courts to enforce their rights against the state, against the state, which is maybe the central government, maybe the state government, maybe agencies of the state. And therefore, the way the wording was there in the bill at every place, in every section, the central government will decide as may be prescribed by the central government, as may be prescribed, which basically means prescribing the rules by the central government. Now, many of these things are leaving it to the choice, the whims and fancies of the central government. In fact, so much so that many of the things have been left to the central government, which they could change through executive orders from time to time, which I thought makes the entire structure very unstable and very, very uncertain. The second aspect is, which is again a structural flaw, is the fact that many of the legislations in this country under the state list are passed in the state legislature. The data is collected by the state agencies, and therefore there is absolutely no logic, legal or otherwise, for assigning to adjudicate on these matters to another central agency who will probably appoint many of its officials in states as adjudicators. It is like having the income tax or the customs or the enforcement directorate in another form through this legislation. And therefore, this has also come very strongly in my dissent note. And you know that I have been speaking and writing about this for last, I think, about a year now at several places, and I do speak about it, the need for a state-level data protection authority. And during the committee's state visits, the field visits, at least the two states, they did, in fact, demand the same thing. In fact, I must say that the committee probably erred by not inviting the state governments right in the beginning during its main consultations, which it should have. And that is why I think this problem in the structural design of the bill that has happened. The third thing that I would like to mention is about the fact that, as again Manishji said, is the fact about a DPA which would be overwhelmed with the kind of work that it has been asked to do in the bill, in the revised bill, or even in the earlier bill. Besides the regulations, besides the codes of practice, besides many other things that it has to do, MOUs with sectoral regulators, which is again going to be very, very tough. The harmonization between the various acts and different, laws in place, which also empowers a particular authority to collect data, would be troublesome. The current bill has taken the easier way out by saying that anything which has been passed in the parliament, so that data can be collected outside the ambit of this, outside the jurisdiction of this bill. I think it will not muster much legal, mandate in the courts of law, even if it gets challenged later, because of the simple fact that this particular right has now been recognized as a fundamental right, which is different from other jurisdictions. In other jurisdictions, it has not been recognized as one of those very basic fundamental rights of citizens. So these are the major flaws as far as the design is concerned. Coming to the specific issue of the privacy and rights of minors, I would suggest, strongly suggest that I had written a piece in the Economic Times on March 4th, 21 on this matter when the bill had not yet been introduced, though it had been finalized. There I talk about the typology of risks that the OECD talks about, and that is the internet risk, that is risk from the internet, then the risk from a consumer point perspective, and the third one is the privacy and security risk. Now, this particular bill addresses the issue of privacy and security risk, but it doesn't take away the fact that there are still internet risks and there are still consumer risks, which are there and which a child will face. And those risks will probably be addressed, are getting addressed in different legislations, but all these three legislations have to live in harmony, have to be synchronized. Therefore, when they have fixed the age of 18 years, keeping the Contract Act in view, I still thought that as far as this bill is concerned, they could have had a provision notwithstanding anything contained, this kind of clause, because a graded age discrimination or age verification exercise would probably have done well to the bill. I say so because of whatever your survey has revealed, that young guys who are the digital natives, the parents are actually the digital migrants. So how can the parents be, giving consent on behalf of their child to allow to access the internet or services given by different data fiduciaries? And having said so, one must also realize the geographical and cultural differences across the country. Let's say people living in remote areas in Malkangiri, or let us say in Sikkim, where even internet connection may not be there. And if let's say the areas where the level of education is very low, and in rural areas of remote areas, now how do you have put everything in one size fits all kind of a strategy approach. So I don't think, while operationalizing this particular provision, it would be easy for the DPA to balance the interest of the children and the interest of privacy. The benefits that should accrue to the children by accessing the internet or accessing various services and applications and whatever should actually be made available to them. That access should be available to them even without their parents' consent, because the parents may not be knowing even that what are those benefits that are going to come through the internet. For example, when I was a student, I never had all these Baijus and all this kind of people, all this kind of applications and all this kind of service providers. One used to go to the library and read the books by pulling them out from the shelves. So I think the times have changed. And then there is one more point which I wanted to point out, is the fact that there's a lot of children's data which is kept in manual form as well. So these manual data, I do not know, there's an omnibus provision in the bill which says that there can be exemption for this, but whether to have an omnibus exemption for data stored manually of children at schools and colleges in rural areas, remote areas, is it correct? Or shouldn't it be covered under the Act? Now, these are some of the operational issues with regard to age that would happen. I would have loved to have a graded approach towards this. As Manishji said, in the Rajya Sabha, when it comes, probably this could be discussed. Of course, the issue of state-level data protection authorities would arise. In fact, the state level, had there been a state-level data protection authority, then some of these issues relating to geographical and cultural differences could have been addressed much better rather than a central, monolithic organization like as has been conceived currently under the bill. The other point which I thought would be important is the fact that one side is the consent aspect. The other one, even after the parent has given consent for children's data to be collected by a data fiduciary, and I think it is rightly, I think that we must give it to the committee that removal of the provision of a guardian data fiduciary is, I think, good, because no data is completely, of children, and could probably be mixed data sets. So any data fiduciary which is handling all kinds of data would be subjected to this. But I think after taking the parents' consent, there is always the possibility that since the consent has been obtained, some kind of harm, if it happens unintentionally or intentionally, just because consent has been taken, the data fiduciary will not be held to task. That should not happen. So a harm-based model in case of children's data would have been, I think, much more appropriate. The time is not yet gone, because we can still have that in the form of regulations and rules. Also, I think the punishment, I was fortunately a member of a committee which was set up for dealing with child pornography in the Rajya Sabha, one ad hoc committee which was chaired by Jairam Rameshji. And there we had said that the punishment for dealing with children data in a very different context, that is for child pornography, generation, dissemination, should be dealt with very strongly. I think this alignment of the punishment criminality of such action between this bill and the criminal procedure IPC and the IT Act and all, I think these are the things that the DPA has to work on, the government has to work on, and if you people actually work on and give us suggestions, I think that would be taken to the floor of the Parliament. Lastly, I would end by saying that the decision of what kind of there was this comparison given between this US and UK and what kind of access has been given to data fiduciaries. But you must realize that we are coming out with a data protection regime or data protection law, which is going to be the first of its kind, which is one of the most significant legislations. It will have several things to do with many of these sectoral regulators who are already well entrenched. And therefore, I think as the situation evolves, the law should evolve. It should be a very lively document, because, as you know, in the technology space, regulation always lags behind technology. And as the technology leapfrogs, I'm sure the issue of how to identify the child, what kind of document to use, whether an Aadhaar would be sufficient and there is no need for anything else, data minimization issues, all these would probably get resolved. Thank you so much.
Thank you so much, sir. There were a few questions and, in the chat, and there were comments about age, the age of children, etc. I would like to bring in Mr. Tiwari if you want to comment on anything which Dr. Patnaik said. And I think Nikhil had a quick question. Nikhil, do you want to share your question? And do make it quick.
I'll make it quick. Thank you, Amrita, and thank you, Mr. Tiwari, Dr. Patnaik, for your comments. I actually had a couple of questions, but I'll just throw them at you quickly in case you want to address them. One was, what was the discussion around the manner of verification that took place? And is this going to be something on the lines of, submitting an ID, or are there going to be multiple modes of easy verification models, which may not necessarily be definitive, but might be instructive, or in which case is there going to be liability on the data fiduciary if they incorrectly verify, let's say if a child gives the wrong date of birth, etc., etc. So just wanted to understand from that aspect. There was a clause, secondly, there was a clause that was removed about, the best interests of the child. Now that's something that globally is, what we've seen is that it's also being incorporated in order to give a little leeway to data fiduciaries. So why was that removed? And also, why wasn't a separate law for children considered, given that this requires a separate debate and discussion and understanding? And in that sense, aren't the clauses a bit too restrictive in their current form in terms of the rights of children to access the internet? Thank you.
Thanks, Nikhil. Mr. Tiwari, would you like to go ahead? And also there was a question from one of the participants as to what can we expect next, now that the report is submitted? What are the timelines?
Thank you very much. I just wanted to supplement what Dr. Amar Patnaik had said. You see, fundamentally, the manner in which the bill has been structured, it gives an overriding veto to the government. In fact, I think there is a particular section towards the end of the bill which says that the Data Protection Authority would be bound by the directions.
86, section 86 and now 87 maybe.
87.
Yeah, and it says that what is public policy will be determined by the government, and it will be binding on the Data Protection Authority to observe that.
I think it goes, Dr. Patnaik, further than that, which says that the DPA would be bound not only on questions of policy. So therefore, in fact, the government's directions to the DPA actually go beyond the narrow remit of policy, which essentially says that the government is going to lay down the writ as to what the DPA will do and what the DPA will not do, which essentially takes away the independence of the regulator completely. And I don't think that this is going to stand the test of legal scrutiny. This was pointed out by each of us when the bill was being discussed, and that's why most of us, I think, have dissented to this particular clause. But coming specifically to Nikhil's question about verification, as you're all aware, some of you who've covered the media remit that I have extremely strong views on anonymity masquerading as privacy in the digital space. And that's why I had very, very strongly argued passionately for hours and hours in the JPC or the JCP that there should be mandatory verification of every social media user. And if that mandatory verification is not done, the social media intermediaries should be put to very strict liability in terms of the provisions of the bill. Other members were of the view that this should not really form a part of the data protection bill, but should actually find its place in a separate legislation on social intermediaries. In fact, Dr. Amar Patnaik was one of the votaries of that particular view. So be that as it may, verification is going to be an extremely tricky issue. And frankly, I don't think that the committee really wrapped its head around as to how this verification mechanism is going to play itself out. Because eventually, till the time you are not going to submit some kind of government authorized ID. For example, I don't know whether in the case of the child, what would it be? Would it be a school identity card, or would it be an Aadhaar card, or something of that kind, which then would indemnify the data fiduciary to some extent? Because if you submit a forged Aadhaar card, or if you submit a fake school ID, then obviously it is not reasonable to expect the liability to really devolve upon the data fiduciary. So this is a complete and absolute minefield, and that's why I had proposed that, look, let's make it graded consent. I mean, let's leave some of the space completely free. Some of the items that I mentioned in my dissent on this particular clause, that those learning websites, etc., leave them completely free. Let's not ask for any any age verification, but for others, you may want to have a certain form of age verification in order to protect the child as also the personal data of the child, which is really the remit of the bill. And interestingly, this is no longer a personal data protection bill. It is a data protection. In fact, there was a lot of debate on this in the JCP, and if you would look at the title and the long title of the bill, it is no longer personal data protection, it is data protection, and that's why there are concerns with regard to non-personal data also. Insofar as removing the clause, best interest of the child is concerned, in my humble estimation, it was too ambiguous. It was too vague. Who really determines what best interests are? How do you define best interests? And as Dr. Patnaik was pointing out, there are cultural sensitivities, geographical sensitivities. You would have certain things which may be accepted. And I'm not giving a snootish example, but in Tony, South Mumbai, which may not really be accepted in parts of my constituency, which is very deep and rural, because there are different social modes in this country, and of course the whole digital space is extremely troubling. In fact, a young lawyer colleague of mine, just before we started this, actually sent me a very disturbing thread about what is being discussed by children on Clubhouse. That thread is there on Twitter. In fact, I hesitate to even articulate its contents before such an august audience. So therefore, we are really living in a thicket of depravity, if I may say. And this anonymity on social media has allowed the worst instincts of society to manifest themselves in the public space, and this will have to be proscribed to some extent. So therefore, that's why I'm saying that the Data Protection Authority is going to have its hands full. I do not really know as to how they are going to fine tune and really whittle the regulations down to an implementable pinpoint. Yes, the bill has laid down certain general principles, but these general principles, each of them, when you try and dissect it and you try and sort of come up with an implementable definition, is definitely going to be a nightmare.
Thank you. So, Dr. Patnaik, would you want to?
No, I entirely agree with Manishi, because I think what is in the best interest of the child, let's face facts, I think it will be determined by his probably parents and close people, close family, and maybe the next level would be children, teachers and friends, could be whatever. So it was very ambiguous, and I think it was best left out of the provisions of the bill. But the issue relating to age, another issue which was discussed, I remember, that currently, if a minor wants to get a SIM card, he would not be, I think, allowed to get the SIM card. He would require the permission, probably. It's only a major who is allowed to have a SIM card. So I think that is why the discussion was in having a fixed age of 18 years. But I still feel that if you balance the benefits that could have accrued, that is the lost opportunity, and the privacy of the child that is ensured by having this age, I think the child is going to lose out. So some other mechanism has to be. Currently, the bill is already cast in stone and is going to be introduced in the Parliament very shortly. As I understand, there's a cabinet note which is being prepared for introduction in the budget session. It will come up for discussion in the Lok Sabha and the Rajya Sabha. It has been introduced in the Lok Sabha, so it will start from there. So to change to bring in a graded age verification system may be difficult at this stage. However, I have a feeling that the rules could actually come in to explain this and contextualize this to say that in these circumstances, Manish ji was saying, in these circumstances, the age limit of 18 would apply, and in other cases, a lower threshold would apply. I think it will be smart of the government to do this, because otherwise we'll be depriving a whole generation of people from accessing knowledge banks, which is already there in the internet space. Nikhil asked about the way forward. The way forward, as I said, is that bill is most likely going to be there in the Parliament, Lok Sabha and Rajya Sabha. But I, for example, am pretty certain that in the Rajya Sabha, which is for the council, it is the states interests which are represented the most in the Council of States, more than the Parliament, which is more constituencies, more than the Lok Sabha, which is more constituency oriented. The states will take up this issue of the need for having a state-level data protection authority, and if it does happen, then I think I foresee a demand for the bill being referred to the select committee of the Rajya Sabha itself to look into this, which will again delay the bill probably. But I think it is better to have a comprehensive legislation than have a legislation which will have a huge amount of federal override of states' interests. Already it is drawing the attention of the Parliament, let's say, in case of GST, in case of the devolution of taxes, money being reduced from the total central pool. So this should not be the last straw again. There's another point to this. Or even, let's say, the agriculture, the thought that everyone thought that it was a state bill and therefore should have been passed in the states. So I think that the bill would get extensively debated in both the houses, and let's wait how it goes in both the houses insofar as the passing of the bill is.
Thank you so much.
Can I just add one line before move on to your next speaker? What really troubles me, and that brings me back to the point that I raised right at the inception of this discussion, is the very constitutionality of this bill. That does it really measure up on the touchstone of the right to privacy judgment, which is a 9-judge bench judgment to the Supreme Court? And the more that I think about it, the more I find that the bill as it is currently structured may not be found to be constitutional. And that is one aspect which, unfortunately, the government is not prepared to consider. I mean, there was an extensive debate on Section 35. There was an extensive debate on Section 12. Some of the other sections which give breakout or escape routes to the government, but the government is not willing to concede even a single centimeter. And so therefore, I think we are in for a fairly long haul before the lay of this land, before the lay of this bill actually gets settled.
Thank you so much, Mr. Tiwari and Dr. Patnaik, for sharing your views and also, the various aspects, which some of it aligns with our views, especially the age verification, the tracking part, though tracking should not be allowed because of various abuses to children, but in certain cases you do need it. So obviously, if there can be some provisions, or a graded approach, it would be much better. And obviously, the views of children should be taken into consideration too. Many a times, children who are 16 to 18 may not want to take consent for many things from their parents. There are, it's not that everything they do is wrong. There may be certain things they do wrong on the internet, but there may be certain things which is needed for their growth. And many times parents are not too open to what the children are wanting to do online too. So, there are issues, but obviously it's in the right direction, but certain things need to be corrected. But there are concerns, as Mr. Tiwari shared, about the government's role in the entire bill. But thank you so much for your interventions. In case there is anything else you want to add, please feel free. Else we'll go to the next speakers, if that's okay with you.
Thank you very much. And
Thank you so much.
afraid I'll have to leave you at this juncture, but wish you all the best for your deliberations. And we look forward to any constructive suggestions, which we would try and flag when the bill comes up for discussion in both the houses of Parliament.
Sure, sir. Thank you so much. We'll try to make a report of this event and share it. Also, we'll try to come up with a community document, which hopefully will have more stakeholders in, discussing the issues, which we hopefully would be at least listened or seen for once. Thank you so much.
Thank you.
So thank you, Amrita. Even I have to leave. Thank you so much to CUTS for organizing this webinar, and I look forward to the deliberations to be sent to me. Thank you so much.
Thank you so much.
And thank you, Manishji. All the best to you.
Thank you, Doctor. Thank you. Thank you.
All the best to you. You didn't respond to that.
That cuts many ways these days.
See you, bye.
So next we have a panel discussion, but before that, for the participants, we have a question. I will be sharing my screen. Siptin, would you please put in the question? If you can go to menti.com, just give me a moment. And if you can see my screen, there is a question for you. You need to go to menti.com and use the code 76575986. All of you can do it. Your names will not come, so you can use it. Go to menti.com, use the code 76575986. The question is, what do you think are the areas which need to be addressed in the proposed Data Protection Bill 2021 with respect to minors' data? Apart from what was discussed, or even if you want to share this, you could do so. We just want your perspective, because we may be thinking from one particular point of view, but you may be thinking from a different view. So this would actually help our speakers too. If you can just share it, go to menti.com, www.menti.com, and use the code 7657 5986. If you can put in your thoughts on what are the areas which need to be addressed, especially related to minors' data. I'm giving you 2 minutes for this. And I will share the screen again. We are coming up with some points. I hope you can see my screen. So we have words coming up like age verification, data security, threshold age, anti-authoritarian, manner of consent, data exploitation, tokenization of identity, online harm. I give you another minute. Your names are not going to come out, so you please feel free to use it. Anything else you want to add? You can keep it adding, but these are some words which have come. I'll share it later also with you, but these are some words which are coming up. You can keep putting in your words. We'll share it later. So we'll go to the next section, as I said, where, and this is for an hour. And I primarily have two set of questions for the speakers. And, I would request you to restrict it to 5 minutes. The first is, while, the issues of 18 years, parental consent, removing the concept of guardian data fiduciary, or issues related to age verification or prohibition on tracking have been highlighted as areas that need to be addressed. From your perspective or your stakeholders' perspective, are these legitimate concerns? Also, what are the hits and misses in the bill, with respect to the earlier bill related to minors' data? And my second question would be, from your perspective, what constructive regulations and codes of practices should look like for protecting minors and, specifically their privacy and right? So I would go to the first question first, and I will direct it towards Uttara and Chandrasekhar because you represent more from the industry perspective. So what are the hits and misses? And from the industry perspective, or a company who has a significant user base, Uttara, for example, you, comprising of teenagers or young adults, what do you see are the main challenges? And will these rules increase compliance cost? So who would like to go first? Uttara, would you like to go first?
Sure, I can go first. Thank you so much. Firstly, I'd like to apologize to all of the participants that have shown up as Uttara Ganesh. It definitely feels like some sort of Ravana-style metaverse takeover, so sorry about that. But jokes aside, thank you, Amrita, for calling me to this discussion. For today, just to answer your question, I think there's two broad points I'd like to raise in terms of what we think could do with some changing, right? So number one is age of consent and the complexities presented by parental consent, including compliance, to your point. And the second is on age verification, right? And how there may be some inherent tensions between verification of age and perhaps the broader objectives of data protection. So first off, I'd like to say that, SNAP obviously shares the JPC's concerns pertaining to the harmful processing of personal data, right? But our hope is that this discussion will persuade Native perhaps to consider an approach that enables young people to have more autonomy over the processing of their personal data. So on the age of consent, right? So you're right, on Snapchat, we do have a lot of young people. About 75% of our user group is between the ages of 13 and 24. And what are they using the platform for? To foster connections with their friends, to learn about a cause and advocate for it, access mental health resources, talk about reproductive health, and sometimes even learning a skill, right? And if we zoom out for a second, I think we can reasonably assume that because of the pandemic, we've seen sort of a massive acceleration of children using the internet in general, and that this will continue. So the reason I raise this is, the minute we require anyone under the age of 18 to obtain parental consent before they want to do any of these things, we're effectively discouraging businesses from offering beneficial content and services to young persons. And and why is this discouraging? It's because of the complexities that flow from creating an obligation, right, for parental consent, and effectively, you're sort of assuming that the agency is taken away from young people as well. For Snapchat, the challenges are often, in terms of creating this parental consent flow. Parents are actually not users of Snapchat, and therefore our solutions will have to be off-platform. So, for instance, email, right? That would be our mechanism to verify parental consent. And as you will know, this will obviously be a pretty manual process and will require privacy support resources as well as engineering resources to build that consent flow. So that is, of course, a problem. I'll allow Aparajita and others to sort of speak about fundamentally how this sort of, there's of course this technical problem, but there's also sort of agency-related issues that you create from this mechanism. The other point I'd like to make, of course, is on the friction between the age verification requirements and some other provisions, specifically data minimization requirements, for instance, or a provision like 16.4, right, which prevents profiling, tracking, behavioral monitoring of data. Now, frankly, there's no debate on the fact that harmful content should not be targeted at children, and Snap is aligned with that. In fact, we data minimize and we are against harmful targeting. But we note actually that this particular provision, right, it has some tensions with the requirements for age verifications to the extent that you'll need to actually process the personal data of children for the purposes of age assurance. And I suspect there may be similar tensions with data minimization requirements as well. I do want to state here that, the UK ICO last year, they published an opinion where they acknowledged that this verification process is pretty complex. And they actually call out risks around discrimination, right? Particularly around minority groups who are less likely to have government IDs, for instance, and the privacy impact really of mass collection and retention of IDs, for example. They also talk about sort of limitations in the freedom of expression and ask questions around the financial implications of such proposals, right? So I guess it is for this reason that we're seeing that governments and regulators the world over are not necessarily rushing forward to recommend age verification as a requirement just yet, and are sort of going slow and taking some time to consult with stakeholders to arrive at a solution that works and is sort of technically feasible as well. So I'll stop there and allow Chandrasekhar to go ahead. Thank you.
Thanks, Sutra. I think CNIL also raised a concern that, the age verification part is pretty cumbersome, as in recently. I think in October, they raised a note on it. So Chandrasekhar, would you like to come in? You've been working earlier in your earlier avatar on this.
Yes. So good afternoon, everybody. So basically, I think in this case, the devil is in the details. So I think we are probably fearing this clause a little bit more than we ought to. I feel that the entire legislation, it has got conflated where security and privacy are both getting mixed and being seen sort of interchangeably. The second problem which is coming is that a lot of emphasis is being given to the impact of this age gating with respect to social media and social media intermediaries. But if you see and break the entire universe into different segments, you will have, for example, a lot of schools. Now, the schools will be having data of the children, and there would be a proper parental consent. They would be sending only appropriate kind of data to the students who are doing their classes online. And likewise, there are various other segments of the entire population. Now, where the problem comes is areas where there is a possibility of complete anonymity and possibility of actually tracking the children and then pushing them towards things which are not really desirable. The second thing which will happen is that suppose a child goes on to the net and is browsing certain sites, then we need to be conscious about what is the kind of cookies that they are collecting. Now, as far as as far as technology solutions are concerned, there are currently many technology solutions through which the parents can control the kind of content which the child can browse. But again, the problem is that it is very easy to overcome this. So broadly, I feel that I'm open to questions. I'm not going making my talk very long. Broadly, I feel that the age of 18 is a little bit of an overkill. Probably that age should come to about 15. The second point that I have is that when the Data Protection Authority comes, it will be possible for us to minimize the kind of problem by doing some kind of an analysis as to what will be the potential harm, which are the platforms which need to be a little more careful, which are the platforms which need which can go with one kind of a blanket approval. Like, for example, schools, we can have something for coaching institutions, we can have things like that. So if there is a graded approach, it will be possible for us to make this stipulation work. Thank you.
Thank you, Chandrasekhar. May I request Aparajita to share from, you represent the interest of the youth and the minors. How do you look at these provisions? What do you see as the concerns, or is everything okay?
Right. Amrita, thank you so much for inviting me to this discussion. Also, because especially I feel like, in many of these discussions that is happening on different platforms, youth are not really represented. I'm not the young person who is being spoken about. But at WILAC, we work with mostly teenagers, and we one of our programs, in fact, looks at how they can use social media to talk about the issues that they really care about. I agree with everything that has been said here. 18 is such an overkill, especially after the pandemic. I mean, the ASAR report also shows that even in government schools, etc., the internet penetration has increased so much in the last 2 years. Your entire education system is running on internet, and you are taking the agency from kids for. And while we all understand that there are risks of being online, but those risks are the same for children. But I mean, even for older people, I find my parents to be even more vulnerable on the internet as more than the children who we work with. So I think definitely 18 is an overkill. I was in fact very disappointed to see that the GPC has not revised it, even though multiple representations were sent to the GPC. And in fact, even in the language that they have used within the report, and I can actually just read it out of here, it was, it made me laugh a little bit. It said that just because some children think that, they are older doesn't make them, adults, and they should not suffer. And this is in the report, right? But that is the approach that we've had to this. What we require is actually a more nuanced approach. And I think the design code prescribed by the ICO in UK is a great example. They are actually shifting the responsibility on the platforms, but they're also encouraging them, because as Chandrasekhar was saying, data fiduciaries are different in nature, and everybody has a different kind of harm that can be caused to children depending on the use case of that platform. And therefore, it is very important for each platform to think about what privacy by design looks like for children. And while Dr. Patnaik and Mr. Manish Tiwari said that best interest is a very vague term, but I think there has been a lot of thinking around this globally. There is a UN standard of what best interest means. There is it's defined under the UK age appropriate design code as well. So there are many frameworks that are already there, and I felt the JPC. I mean, now I guess the ship has sailed, but I think now even if METI is looking at another version of the bill, I don't know how much they will actually change from this version, but there is an opportunity for us to look at those frameworks and actually focus more on what platforms can do to keep children safe rather than taking agency from them. And that's what I would like to say.
Thanks a lot, Aparajita. We will come back with you for some questions, but Amol, what do you think are the hits and misses apart from what has been discussed? Anything else which you feel?
Sure. I think there are a lot of issues which have already been covered, Amrita. But I think given that we come from a consumer perspective, we also, like Aparajita, work a lot with young people, young consumers across sectors, including in digital economy. So I think one of the things which could have been incorporated in the report or in the bill itself was how does the regulator and the stakeholders work together with consumer organizations and youth organizations. As Aparajita had mentioned that globally there is a movement to involve young users more into decision making about digital economy. And India, as you had mentioned also, that around 40% of the users are young users. So it just defies any logic that we are making any decisions about young users without taking their perspectives into account. Now, how can this be done is there are a lot of community-based organizations who are working on the grassroots, CUTS being one of them, who are working with children to empower them, educate them, and also sort of help them make informed choices and opinions. We are seeing a lot of developments across sectors, including, say, financial sector, wherein in the course curriculum, we are incorporating things like how to invest, how to save, and things like that. In our centers in Chittorgarh and Bhilwara in Rajasthan, we run something called as Bal Panchayats. There are youth parliaments which are organized across the world. So if these are some of the initiatives which are happening on ground, why is it that we are excluding children from decisions which are being made about them in terms of access to internet and digital services? Given that there is a lot of exclusionary concerns in case parents do not actually understand the value of access to digital services, and that is also come out very clearly from our survey, as Siddharth had also mentioned, that a lot of parents believe that children are already accessing internet services without their knowledge or consent, and they are okay or comfortable doing so. So there is no reason why they should not continue to do so. I think somebody in the comment section also had pointed out the concern about digital divide, and I think that is remains to a large extent in India, and we should therefore be cognizant of the realities of a country. The second issue which I just wanted to highlight, and I think I have also pasted a link of a paper that we have worked on with respect to global technological developments on age verification and age assessment technologies, is that there is a lot of innovation which is happening in terms of how do you estimate or verify or assess age of children to sort of figure out whether they are talking or disclosing the correct age. And it's the government ID is one of the, but not the only way to estimate or verify age. There could be several mechanisms, both technology based as well as sort of other ID based. So and if we were to focus on one type of ID, we were to restrict innovation in terms of what service providers could do in terms of providing or enabling access to digital services to children, while also minimizing the tracking and also estimating their age to the sort of to a correct manner. So I'll just stop at that. Maybe I'll come back to more in the second round.
Thanks, Amar. You've raised a very important point, and later, Aprajit, I would also like to hear from you as how do you think we should engage more, minors, I would say, or young adults. We would have loved to have some, at least, representation of young adults here. Unfortunately, we couldn't, but we would definitely like to have them more. We are discussing them without them being there in the table. That's the irony. When we're talking about digital divide, I think there is also, looking at the socioeconomic framework of the country, I think the gender digital divide is also going to be impacted to a lot. So now I'll bring in Nikhil. Nikhil has been looking at privacy from the media aspect. His Medianama has been in the forefront in discussing the privacy issues. He has an event tomorrow and day after also, and he himself has said that he was a young internet user, an ardent user. So Nikhil, I'd like to hear your views on the hits and misses.
Thanks, Amrita. I was going to start with a joke saying that will the real Uttara Ganesh please stand up, given that there are many of them.
That's a good one, actually.
I know. But it also shows my age because I came onto the internet around the time that that basically Eminem was popular. But I mean, with the real Slim Shady song. Look, let me just start off by saying that there is clearly a need to protect the data of children on the internet, because I've received emails from like random email addresses trying to sell me students' database of students who've given this exam or that exam. And very clearly, there are people who are failing to protect the data of children. But I think what we're doing here with this particular bill is trying to bucket everyone together and saying that such kind of illegal activity is the same as any data fiduciary collecting data on children. And that lack of nuance and also a lack of technical understanding is basically what is going to disenfranchise children and also younger, almost adults, older teenagers from the internet. And I'm very, very worried about that because I was 16 when I first came online, right? And basically, no one in the family knew how to use the internet, and one learned along the way. And I guess that's true for our country, where it's basically, you expect guardians to figure out how to give consent to children in many parts of the country, where it is the children who are teaching the guardians how to use the internet. Look, it's not going to, it's just going to break for so many people. We have to remember that I mean, in my mind, it's just absolute nonsense to have the age of consent to be able to access the internet at 18. The JPC and whatever the Contract Act might say, whatever those restrictions are, they need to change in order to ensure that children can get online. It can't be the other way around, that just because the Contract Act has a stipulation that children, that you need to be 18 to be able to consent to a contract, you need that entire mechanism. You're going to disenfranchise far too many people. How many parents are going to be willing to even give consent or have the patience to give consent to every single thing that a child accesses? And I'm afraid that the liability of that will fall on the data fiduciary that's supposed to verify the age of a child. How will they verify if they're going to be potentially held liable? And will they then need ID cards for everyone? I believe that, to my mind, there seems to be a kind of a disconnect here, because if you read the text of the law, I'm not a lawyer, so the lawyers can please correct me on this. Clause 16 says, every data fiduciary shall process the personal data of a child in such a manner that protects the right of a child, right? That's 16.1. 16.4 says, the data fiduciary shall be barred from profiling, tracking, or behavioral monitoring of or targeted advertising directed at children, and undertaking any processing of personal data that can cause a significant harm to the child. Now, the positioning of the comma here is important, because are they saying that they're also barred from all kinds of tracking and profiling and behavioral monitoring? If that's the case, then isn't that in contrast, or isn't that in opposition to the first part, saying that they will process the personal data in such a manner that protects the right of a child? So the lawyers can just correct me on this part. But what happens to, for example, proctoring of examinations? Isn't that tracking a child? What happens to, say, something like a Khan Academy, where they make or a Byju's, where they make recommendations to children? How can they make those recommendations on the basis of their performance without profiling them? I asked a question in chat about whether it is possible for someone to remain registered or logged into something without tracking. So the prevention of tracking means that you can't put a cookie. If you can't put a cookie, then you can't track a session. And so how does this even work? Did these people, all these honorable MPs and eminent people in the JPC, did they understand the technical aspects of why a certain amount of tracking is necessary? That is all tracking bad? What happens to the deployment of AI in education? That's based on behavioral tracking and basically tracking the performance of a child. So there are just so many unanswered questions related to this. And that's why my question to them was about, how do you verify, the fact that a child is a child over here? And many children don't even have ID cards, of course, and they'll say submit an Aadhaar, and that's a whole different problem waiting to sort of blow up. I remember one of the first few stories that we covered on the Aadhaar data leaks was the fact that a school in Telangana had exposed the Aadhaar data of children that was collecting on the directions of some government department or the other. So I don't think this is really a solution, and I don't know whether they've thought things through. There was one point that in the presentation that Kat said made that I really liked. Users don't want to be tracked, and majority of users don't want to be tracked all the time by their parents in terms of children, and quite a significant number of parents also don't want to track the children all the time. And if you look at that age group from, say, let's say 10 to 18, you will see that the propensity and the willingness of parents to track their children reduces as the child grows older, as the child matures. And so you have to, therefore have a graded approach to this also, and perhaps leave it to the judgment of a parent because at the end of the day, it is their responsibility. What you're ending up with is a highly paternalistic approach to regulation of children's access to the internet at a time when they can probably learn the most from the internet, and probably more than they would ever learn from the school, and more than they would probably ever learn from their parents.
Thanks, Nikhil. Incidentally, Rahul raises an irony that 15 is a legal age for employment. Employment is fine, but the app is not. So that's it. So we'll go to the next question, and I'll take you at the end, Nikhil. So the question is, what could be the way forward in terms of what could be the constructive regulations or codes of practice for protecting minors' privacy and their rights. So Aparajita and Amol, when you are sharing your views, can you also share in your opinion or more on, how to involve adults in decision making, and children also face various problematic experiences online. And is the data protection bill the right avenue for addressing these same, or how else can it be addressed? So this is for you. Uttara and Chandrasekhar, when you are responding, I would like to hear from you if you can share more on the measures which industry has been taking to ensure child safety online, and if there are any good practices you could recommend for verifying the age of users, which is at least, which has least privacy, which is not so intrusive. So these are certain pointers, but you can feel free to share what you want to share. So I'll start with Aparajita, Amol, Uttara, Chandrasekhar, and then Nikhil.
Okay, great. Thanks, Amrita. And I'm glad that you brought up the gender aspect. That's something that I forgot to mention. So we had multiple consultations around this, sessions and programs. And, girls in the rooms where we had this discussion with young people, in fact, were very concerned about this clause, because already we see a sort of like, divide in the access that they get to phones. For example, like even in middle class urban households, we have seen that, boys, for example, get phones at an earlier age, girls get it at a later age. And again, if you have this kind of parental consent, then, you are actually subjecting women to a lot more scrutiny. And because sometimes parents want to be extra careful when it comes to girls, they might actually deny them permissions. And that is something that has not been taken into account. So that gender lens is definitely missing from this entire piece about parental consent. I think the way forward from here, to be very frank, I am a great believer in platform design. I think that really is what determines how we behave on platforms. I think everything else can be in the, but forget children, even people like us who come to these discussions and discuss the PDP bill, we are more, guided by what platforms make us do than our own agency. And I think in that sense, there needs to be a lot more focus on design and default settings for children. And what nudges are platforms using to make sure that children are not in the line of harm. And for that, if they need to track data, they should be allowed to track data, in fact, because I think a lot of platforms have, features which also enable them to track data. If, for example, if something seems suspicious, if a suspicious profile is targeting a child again and again, and if they're able to track that, then we should use the technology to be able to do that and protect the child. Also, as I said earlier, not all platforms are the same. So the kind of harms that can come from each platform is also going to be different. So we need a principles level framework instead of having these blanket sort of requirements, which just say, black and white. And I'm glad that Nikhil pointed out that clause, because I thought that I'm the only one who's not able to understand what is the meaning of this comma and what does it actually mean for platforms. But we can't have those sort of, blanket bans. We need to have a principles level framework. Each platform needs to think about how that applies to their platform, what are the harms that can come to children from their platform, and they need to provide a justification. We need to have a conversation, because tech also, I mean, by the time DPA actually is fully functional, which is 2 years from whenever the legislation is going to be passed, we might have a different sort of technology solution for age verification for many things that we are discussing here. So we cannot keep on updating our legislation, but what we need is a principles level framework, and we need platforms to have an open discussion. Harms can come to the users, and then sort of decide on what privacy by design is for children. I think that is the way forward. And DPA, we've already spoken about the fact that they will have a lot cut out for them once it's settled. So therefore, maybe I think, as Nikhil was saying, maybe have a separate sort of, I don't know, either legislation or a code which is just focusing on how children's data is being processed or handled by data fiduciaries.
Thank you. Amar?
Sure, thanks. So I think clearly there could be things which could be done at the platform level in terms of what service providers could do and what technology could do through innovation. But there are clearly things which can be done at an offline level also. As I had mentioned earlier as well, that the initiatives in the online world will need to go hand in hand with the initiatives in the offline world. There is need to ensure that whatever we are saying in terms of graded approach and platforms taking more responsibility and opening up to discussions and sort of initiatives is implementable, and sort of they are held accountable to what they are planning to do. And for that to happen, we need to ensure that there are sort of entities, civil society organizations, consumer-facing organizations, youth organizations who who act as sort of flag bearers of to check what platforms are doing and what they are not doing, and sort of highlight to the regulators as well as platforms that there is something here that you are going wrong and this is what you need to course correct. So in addition to that, I agree with Prajita when she says that there is need for a principle-based approach and more sort of discussion-oriented approach. And that is something that could be incorporated in the bill itself. So whenever there is a rule which the government plans to come up, or whenever there is a regulation which the DPA plans to come up, it must be mandated that that happens through inclusive stakeholder consultations, and particularly when it is about minors data protection, necessarily the government and or the regulator needs to go to organizations who are working with such young users to understand their point of view and then incorporate that adequately in the rules and the regulations. Cost-benefit analysis needs to be mandated whenever there is any new rule or regulation which comes into sort of place in terms of to what extent tracking can be done, to what extent or what technology can be used. So the more consultation we have, the more focus we have on sort of offline means in addition to online means, and better grievance redress mechanisms we put in place, the better we'll be able to protect minors without necessarily compromising their right to access the digital economy. And last but not the least, I agree with Aparajita and others, Nikhil also, that there's a need for a special dedicated legislation or section or sort of a portion about minors data or protecting rights of minors. We have seen this happen in other sectors as well. In financial sector, for vulnerable consumers, vulnerable financial consumers, there are dedicated provisions, and therefore something dedicated which talks about minors in the way that can help minor continue to access these services could be a win-win for all. Thank you.
Thank you, Amol. Very important point which you and Aparajita also raised. That is of basically, capacity building amongst not only the young adults but everyone who is around them, their parents, their caregivers, everyone, because they also need to be at par to manage this. Just giving them the tools to kind of close the tap is not enough. They need to know how to use it, when to use it. And I like your statement that initiatives offline and online have to go hand in hand. So now I go to Uttara and then Chandrasekhar for their views from the industry perspective.
Thanks, Amrita. I have to say, I do have a lot to agree with in terms of what Aprajita raised about design. I think that at the core of it, platform design is perhaps one of the most important ways to ensure that people in general are safe online, but especially children as well, right? And when you say platform design, from my perspective, I think that you could look at it from a data policies perspective, so how do you collect and manage data? And then you could also sort of look at design from the perspective of the architecture of the application itself, right? So from a Snapchat perspective, I think there are some really different things we do, and which is why I feel like, just like the IT Act, sometimes some of these provisions seem a bit one size fits all. You're sort of subliminally thinking of these ubiquitous platforms, and unfortunately, the people that also get impacted are people with much lesser, resource capacity to actually, think about compliance. So in terms of going back to design, right? Like, what are the data policies that Snap has to make sure that people are safe? And this, of course, has a bearing on minor rights as well. Number one, data minimization, right? So in terms of collecting data, Snap only collects as much data as required to process activities, and there isn't this sort of indefinite storage of people's data into our servers. So there's that sort of is a huge differentiator, I'd like to say, and it sort of speaks to the distinctiveness of different platforms and different business models. There's also the sense of, even in terms of targeting of ads, right? Snap is not, for instance, indulge in micro-targeting of ads. If you look at the dashboard as an advertiser on Snap and you compare that to, say, other advertising platforms, the extent we're not actually targeting people at the level of the individual, and we're sort of more distanced from we're looking at the data in a more aggregated manner and is more distance from specific individuals, right, while making an ad show up. Those are two, I think, very powerful ways in which that design can make a difference. From an in-app perspective as well, right? Of course, ephemerality is a huge feature that is privacy protecting and should be sort of be considered by multiple platforms. But there's also things like, for instance, making sure that your location data is turned off by default, or for instance, where on Snap you can't just speak to anybody if you have their phone number. They have to have added you, and there's no such thing as an others folder. For instance, you have to receive communication directly from somebody who's request you accept it, and it has to be mutual for there to be communication. So to my mind, these are sorts of, and sorry, the other one big design difference I think is, separating in a sense the private and the public spaces on the app itself, right? So if people who use Snapchat know that there isn't, you don't open it into a news feed, and it isn't this sort of feed where you have the news and you have content from, your friends, for instance. At Snap, because of our learnings from just the social media ecosystem in general, there was an intentional separation of content that your friends have put up from versus where you see news, etc. And the other thing also is that every single person, they're sort of almost drawing from the broadcast approach to regulation, right? Where if you're speaking to somebody one-on-one over the phone, there's you sort of assume more privacy than when you're saying something that's being broadcast to millions of people at once. Sort of taking from that understanding, there's also a sense that, hey, we don't want to have vanity metrics on Snap, and you're not broadcasting your points of view. And the minute there's any content that has more than 25 views, it goes under moderation by the AI, as well as, of course, a human moderation as well. And all of the sort of content on Discover, which is our version of a feed, is actually curated. So there is a team that sort of, you can only publish on Discover if you're already like a Snap approved publisher, right? So in a sense, the design from that perspective sort of takes into account some of the risks that you see typically on social media, and sort of tries to sort of address that at the level of design itself. So, I will say that, in terms of the bill, etc., as well, when you see that there are many businesses that are taking a privacy bet by thoughtfully thinking about design of their applications, it does seem like bills like these are very one size fits all. And I think Aparajita's point earlier about the fact that, you sort of stifle all sizes of companies because of, say, a few players that may have these sorts of problems, it becomes definitely sort of a sore point as well.
Thanks, Sutra. Chandrasekhar?
So I would just briefly touch upon the kind of technical aids which are available for controlling harm to children. Basically at a network level, there is a monitoring of all the pings and all which are going, and it is seen where, because typically children are a little more vulnerable to the net content, they may click on things which can trigger off bots and trigger off internet DDoS type of attacks. So there is some kind of a network monitoring which goes on. So again, technically it is a processing of the data, but then it goes on at the back end. Then there is also AI, which is monitoring the content for any child pornography and things like that. There are techniques like photo DNA, like once if there is a particular content which has been flagged, if that content again appears onto the internet, then it is automatically blocked. Most of the big platforms, they look at this photo DNA. Of course, there is also content moderation, because if there is some content which is getting viral too fast, there is some amount of moderation that takes place. So this is all at the network level and at the platform level. But when it comes to the user level, there are various softwares and tools. There is parental control which is available on most big softwares. In addition, there are also software tools where you can whitelist certain sites and not whitelist some other sites. Now, then there is also one important aspect to consider in terms of harms, whether the platform is monetizing the processing of data, or whether the platform is monetizing data itself. So where it comes to processing of data, a little bit of a more nuanced approach would probably be required. When I read through the current draft, there is a very curious anomaly which I can point out. It says a data fiduciary shall, before processing, verify the age. So let us say that I am not a data fiduciary who wants to process the data. Then will I allow a child to come onto my platform? So it is not real age gating for entry. It is an age gating for processing. So there is an anomaly. If what they want is to prevent access, then that has to be very clear. So I would strongly recommend that there has to be some kind of a management by objectives. So they should list out A, B, C, D, maybe 10 or 20 things that what platforms cannot do. And once that is listed and that is clear, then each of the platforms can accordingly do. So for example, even for children, as some other speakers have pointed out, if we have some very good coaching class or something which is possible, so the children ought to know. Or if in fact, some of the governments also are processing this data of children to find out what is the propensity of a certain child to drop out of school. So if you are not going to allow the processing of any of this data, you will not get insights as to which children are not attending school, who are likely to drop out, who are not getting noon meal nutrition, and all these are very important insights which people can get from the data. So I'll stop here. Thank you.
Thank you, Chandrasekhar. Very important points you've raised, especially when now most schools, even government schools, are going digitalizing and getting a lot of data. As in, will that also fall under the ambit, or is something which needs to be looked, and especially with smart cities, IoT, etc., and some places where facial recognition is also being used. There is a lot of data being collected. Whether we like it, we don't like it, that's a different thing. So Nikhil, I'll bring you here. You get a lot of varied perspectives from different stakeholders and also from the media. What would be your suggestions?
Well, before that, Amrita, I just wanted to address 2 points. One, when Shekhar had mentioned processing, by definition in the bill, processing includes collection, recording, organizing, structuring, storing, adapting, altering, retrieval, use, alignment or combination, indexing, any disclosure, restriction, erasure, destruction. So the vast definition of processing by itself means that even someone visiting a site, their data is effectively being recorded. So I don't think that, I mean, the scope still remains valid. Sorry to I mean, I just wanted to share that processing means pretty much everything under the sun here. The other was Kuldeep, before he left, had just left a comment about what if a child faces sexual abuse as mobile number and other personal data is shared. That is a single use case, which is an anomaly. And it's also going to happen, let's say, on some platforms which actually disclose the mobile number of a child. And effectively, children are not supposed to have mobile numbers. They can't officially get mobile numbers unless they're above 18, right? So if they had, they would have it in the parents' name. So I think for edge cases, you can't basically restrict all activity for all children everywhere. And like I said, there also needs to be a different graded approach between people who are below 13 and above 13, because their independence, their maturity increases with age, and they need to be able to explore new things and learn new things. And you really don't want to restrict that at this point in time. I would just go back and say that a law is supposed to be more of a guidance for delegated legislation in this case. And I don't think, I mean, this subject by itself is so vast that it should only have been taken a principles-based approach, like Aparajita said, and we both riffing off each other on this one, should have taken a principles-based approach to direct further regulation or further legislation, and set basic principles on the basis of which other laws can be made. So that being so instructive, and also by just randomly putting together words which mean very different things in an internet environment, such as profiling, tracking, they should have left some of these aspects to a more detailed discussion, because there's so many topics in the bill that this really important portion has only got a minor sort of a mention, and it deserves a bill of its own. It deserves a separate regulation of its own. I would hope that MeitY will take this into account and change some of these aspects to make it, in fact, make them a little bit more vague and make it more principle oriented, so that either the DPA can create rules or further legislation can be enacted. Because we also have aspects which have come out in the Rajya Sabha report related to children and particular legal processes related to child sexual abuse. And all of these issues can be combined into a separate legislation, because they need to be, rather than being looked at in a piecemeal basis. I don't know whether there's scope for much change over here, frankly, but I do think, and I wonder if we will see some kind of we'll see some kind of litigation going forward on this, because an entire edtech ecosystem could basically get completely upended, and just for survival, they would probably need to do something about this.
Right. Thank you, Nikhil. The audience may have a few questions, but before that, I would want to bring in Srinidhi. Srinidhi, do you have some comments on, what could be the...
Hi. Yeah, I think I'd be echoing a lot of what other folks have already said. And I think my one sort of guiding guardrail here would be that for a law like this, generally any kind of absolutes may actually end up doing more harm than good. Especially when it comes to children. I think through the course of this discussion, we've also talked about a bunch of competing interests and rights. So creating a safe space for young people to access the internet versus ensuring autonomy, data minimization generally versus collecting more and more data for age verification. I hear Nikhil's exasperation when we were talking about Aadhaar as other official identifiers as just, I'm imagining a scenario where to subscribe to a newsletter, you have to give your Aadhaar number. And I think someone in the comment section had comments had pointed out that Aadhaar and official identifiers are also SPD, sensitive personal data. Yep. So does that mean you have to get explicit consent for that? This is some kind of consent plus explicit consent loop then for the whole situation. And yeah, I think overall also not adding excessive friction to a platform, and by extension friction to a child's or a young adult's ability to access the internet. So overall would sort of call for a risk-based approach or risk-based codes of practice And yeah, I'd also echo a lot of, I think, what Aprajita had said and other speakers as well, on not everything can also be solved within the data protection law. I think a lot of it is also policy measures around just generally digital literacy or digital safety being part of school curriculum. And very much, I mean, I think no one can deny that there are very real challenges on the internet when it comes to access and safety. But I'd sort of also caution against putting everything in the law, even within codes of practice for that matter, because of the spectrum of platforms and access that we're talking about.
Thanks, Srinidhi. Is there anyone who wants to share a comment or question? You can raise your hand. Rahul, you wanted to share something, Rahul Sharma?
I had a question for
Yeah,
Srinidhi,
please.
if I may,
Yeah, please go ahead.
Srinidhi, would my reading of 16.4 be correct, that data fiduciaries are in general barred from profiling, tracking, or behavioral monitoring or targeted advertising? And the fact that can cause significant harm is only is related to the targeted is not a prerequisite for this prevention. Would that be correct?
Yeah, no, I think this is one clause that we've discussed internally also extensively as to what would be a more reasonable interpretation. And I think what you pointed out, overall, you look at privacy by design as an approach. You look at 16.1, which also asks you to look at not best interest anymore, that protecting the rights of a child. And I think a more reasonable interpretation here might be to view that first part to be connected to the second part. Because otherwise you're essentially taking away a whole bunch of beneficial profiling, beneficial tracking,
Right.
just a whole bunch of, I guess, use cases which are really not the intention of the law here.
But it is open to interpretation, essentially, right? The way it's put it.
Yeah. I'd argue that it is open to interpretation. It might come down to where the comma is placed, but I think overall, and there are very few other such absolutes to my mind in the data protection law. Very much principle-based approach to it. A lot of the sort of even consent, when we say fair and reasonable processing, a lot of it is the idea being you account for privacy, not that you don't do certain activities. Do certain activities after having accounted for privacy and children's rights. And I'd say that would be the more reasonable interpretation to take here.
Okay, depending on whether you're a law enforcement person or not, right? Fair enough. Thanks.
Right. Is anyone in the audience wants to share any comments, questions? By the time you decide or you raise your hand, I have a question for the audience. Just give me a moment. I will share my screen. Siptin, could you share the second question into the chat? Again, here we would be using the Mentimeter. Just give me a moment. I think the question is, apart from what was discussed today, what are the other areas with respect to minors data that need to be further deliberated? It's the same code. Go to menti.com, use 76575986. Siptim, if you could put it into the chat, please. Apart from what was discussed today, what are the other areas with respect to minors data that needs to be further deliberated? We may have missed certain things. If there is anything, the Menti code is 76575986. I'll put it into the chat also, just give me a moment. I'm giving you another moment. Please share your, if you feel there is anything, we give you 1 minute. If you think, no, that's about it, that's also good, but I don't think that's going to be the case. Okay, I guess we don't have any comments on it. We have another 2 questions. If you want to put in your comments, questions, please put it in. Okay, we have something coming in. I'll just share the screen. I have two more questions for anything else? We have two more questions, but the code of the mentee would be different this time.
Any connection?
So the next question is, it's a different code. Siptin, could you share question 3? This is about what are the most pressing challenges which needs to be deliberated along with data protection for protecting children online. The code here is 8718030. Apart from what we have been discussing, what are the other issues that needs to be deliberated for protecting children online? 8718030. We've been discussing about the provisions of minors in the data protection bill, but apart from it, what other issues needs to be looked at? 8718030. I see a big people here. Anything else?
Amrita, sorry, I think Uttara sort of put in, I think, a question or comment. I don't even know if that.
Yeah, I'll just come to it. I can't, since I'm sharing my screen, I can't see.
Not
But
clear. I'm just clarifying.
which Uttara?
I'm not
Original Uttara.
But I think there's just one question about best interest versus rights of child. I think that does warrant a discussion.
Sure. Please go ahead.
And I just wanted to say that I think by doing this 18 years, we are neither ensuring rights of child, nor are we ensuring best interest of child, because you're not thinking about agency and the right to access internet as a right? You're just, thinking about privacy and security. And best interest, actually, I had copied it and, I've been looking at the UK law, the code that they've come out with in a lot of detail. They've actually defined it really, really well. So that takes into account both rights and, what the best interests are, because frankly, there are so many things that a child can face online. For example, addiction, the constant urge to scroll, etc. Those will not be just addressed by rights as such. So you need that best interest type of language also. So I was hoping, I know that you're going to make a note, etc., on the basis of the discussion that we've had today. So would be great if we could delve a little bit more on this, because I do feel that significantly changes the way we look at clauses related to children's data, if we change that language.
Right, thanks. So anyone else from the panel, would you like to come, discuss, comment on what Uttara has mentioned? This is not the original Uttara, right? This is someone else, I think. The removal of best interest and putting in a rights-based language for protecting children's privacy. Anyone else? And also, I'm not sure if anyone from Aramb is there in the call. They were there. If they would like to come in.
I had a thought here. I was also just wondering if rights in this clause would mean rights of a child generally as guaranteed under Child Rights Convention, or rights under this particular law, because individual rights also has a specific connotation under the data protection law, which is limited to your right to access, rectification, transparency, all of those things. But I'm surely the intent must be to look at the wider spectrum of rights, which might perhaps be better served through a best interest framing, which is a little more globally recognized. But yeah, just wondering how, as a lawyer, just coming down to, I think, legal interpretation and whether we'll only look to the text of this law or outside.
Thanks, Srinidhi. So, we just have another 15 minutes before we conclude or do anything. As we had mentioned, this is one step which we are doing in terms of discussion and perhaps, having a report coming up. But in the second round, we want to have a kind of community document being shared, even if it is not per se pure best practices or codes, but also what we have been discussing in terms of, a separate perhaps legislation or sub-legislation, etc., to look at minors or anything as a community. So we actually from CCAOI, CUTS, International and Internet Society Delhi would actually want, we are looking forward to community members, either individually or your organizations, to if you're interested to be part of it, we would be happy to have you on board with us. For this, we will be sharing out, we'll prepare a rough document, share it out, and you can put in your own views, comments if you want. And this would be an attributable, or you could support the document also or not support it, as in it's up to you. But we are looking at it to be a community document with which we can go to, we all can actually submit it to METI. They look at it, they throw it into the bin, but at least we can do what we should be doing. So this is a request or, for collaboration perhaps of organizations or individuals. If we would be preparing a document and sharing, if in case you are interested, please do contribute or support if you feel it makes sense. So this is something which we wanted to share. And Amol, if you want to share, or Siddharth, anything, please do share. CUTS has some comments which they would also be putting it into the document, and we'll be sharing it. Nikhil, you have a session tomorrow. I'm looking forward to it. Do you want to, in case anyone wants to, participate in that, that's a long and more intense discussion. You can go to Medianama website and register there. Or Nikhil, would you want to put the registration link here? You could do so.
Let me just get the link and put it here.
And once again, we would like to thank all of you for participating in this discussion and spending so much of time with us. That's a substantial amount of time for all the speakers or participants. And we really thank you for it. And we feel that perhaps we need to have more discussions on it. So we have a last, okay, Nikhil has put in his link. We have a last question for you in that regards, in regards of what we have been discussing. And it is again on the Mentimeter. Just give me a moment. I will change the question. And this is more to do with, if you are interested to contribute, this is the question. So you can reach out to us in a separately also. You may not have so much of time to kind of contribute, but if you read it and you support it, that's also fine. You can put in, if you are interested to contribute in shaping a document for minors, no also is okay. If you think it's not a worthwhile activity, that's also okay. If you've not thought about it, that's also okay. So please feel free to use it, and you can share. You can reach out to us. But thank you from my end. But if Amar or any of you want to come share something, please feel free. Amol, Siddharth.
Sure, thank you. Please allow me, on behalf of CUTS International, to also thank my fellow panelists as well as participants. And while I think MPs have left, but it was great to hear their perspective as well. As Amrita has mentioned, we have done a survey and we would be circulating the full survey findings very soon. Hope to receive your thoughts, comments, feedback on the survey. This was first of its kind survey talking to children aged 16 to 18 and on same issues, taking perspectives of parents. Also, we are putting together a policy brief, and we have put together a paper on age verification estimation technologies, link of which is pasted in the chat box. As Amrita had mentioned, we would work with CCAOI to put together the joint submission, which is community driven. We hope to make an impact with that, and we look forward to contributions from all the stakeholders, whether anonymous or otherwise. And please be rest assured that this is not the end of it. We will continue this debate, and we'll continue to speak with policy influencers, bureaucrats, legislators, and people who matter to ensure that rights of minors and young users are enhanced and sort of their interests are protected. Thank you very much.
Thank you so much. And we end the call. And thank you so much for being here, participating, listening, or even speaking and sharing your views. I know you've spent a lot of your precious time online. Thank you so much.
Thank you.
Bye-bye.
Thank you, Amrita. Thank you for putting this together. Really important subject. Thank you.
Thank you.